Assalamu alaikum, everybody. Thank you for joining us today. My name is Amber, and I am one of the team members of the ISGH Job Networking Committee. Our goal is to empower our community in a variety of ways so we can become gainfully employed and contributing members of the greater Houston area. Please stay up to date with our different programs and classes by joining us on Facebook and LinkedIn. We have a special guest today with us, Ms. Misbah Chaudhry. She is an immigration attorney and has been serving the Houston community for a number of years. Ms. Chaudhry is a member of the New York State Bar Association and American Immigration Lawyers Association. She received her Bachelor of Law degree with honors from the University of Punjab and the Master of Law from Indiana University School of Law. She is actively involved with events amongst the Pakistani, Indian, and Bangladeshi community. She has worked with various immigration law firms and has handled countless employment and family-based petitions. Since the Biden administration took over in January, many immigration policy changes have occurred. Ms. Chaudhry will explain some of the changes and answer any questions you have. Please wait until the end of her presentation to ask your questions. You can send me a private message through chat. Thank you so much for joining us today, Ms. Chaudhry. Please go ahead.
Assalamu alaikum to all the viewers and listeners. I'm very excited to be here and part of this wonderful seminar where we can help people find jobs and secure their related to their professions, which is very important. As you know, that Biden administration has taken over in January. And before that, during the last 4 years, there were a number of changes which were conducted, and number of changes, number of plans, which was conducted towards the immigration process. As we all know, that immigration is very detailed law, and there are so many provisions which are involved and so many rules and regulations, and it's always that one regulation or another impacts people in a very strong way. So it's very important to have a very good knowledge of whatever is going on with the immigration, also with the concept of finding jobs, having employment in the United States, having a degree and then implementing this degree in its field. It's very important. It's very important to know how your immigration law or your status goes with your opportunity to attain a job or to find a job and then to keep that job in a legal way. So it's very important to know that what kind of changes are coming towards us in the immigration field. The day Biden administration took over, they introduced a very comprehensive immigration reform bill, which is now before the Senate to become a law. They have to go through a certain process, and then these rules and regulations they turn into laws. So as long as they are bills, they are in front of us, they are proposals, and we are looking into them because we need to know how beneficial they can be for us and to our community and all the people from all around the world who have come to United States to have a life here and to set up their future here. So I'm briefly going to discuss 300 pages, but I'm trying to put them because of, we have certain time period to explain them. So the very important points, very, very important in my understanding, which impact our community and impact our people in a very strong way. So I think so it's very important to know the basics of it. So I'm going to down these provisions in briefly, and then we can discuss them. And then we have certain questions which we already have in front of me. People are asking questions, their concerns, and repeatedly some questions I've noticed is repetition. People, and that shows the anxiety and the anxiousness of the people towards that issue. So we are going to answer those in the most possible way which we can. So come up to the points. Number one, we start with establish an 8-year path to citizenship documented immigrants who arrived in the United January 1st. So I have received many questions with regards to that also, that, oh, so what is the meaning of this provision? So whoever is present in the United States as of January 1st is going to get some status, that is the path to citizen. So in the provision, when it becomes the law, then the things will be more clear, and it implemented, and it will be interpreted in a more clear manner. But what they mean right now is, as of January 1st, whoever will be present in United States, they will be able to follow the path of the 8 years path to the citizenship. Second provision is provide an expedited path to citizenship for farm workers and undocumented young people who arrive in the US as with temporary protected status under DACA. DACA is in the news, in the media for years and years and years, under administration, under other Republican administrations, and now under this Biden administration as well. These are the minor children who have accompanied along with their adults and enter United States, cross the border, and are been living years and years, have attained their education here, have a future here, but not a status. So a Biden administration is very about DACA candidates, so they can get the path to the citizenship. They can follow the path to the citizenship, and they have a clear way to gain the employment. And first, to gain employment, they can have the rights to travel, and then that path leads to the citizenship, which is a very important thing and much weighted thing for them. Also, the farm workers, that is also clear in this bill, that the farm workers, the people who came from all around the world, and they work here in the farming industry, and they will have the right to go to the path of the citizenship, as they work here legally and have some say in the immigration system. Then the third one is that it doesn't seem like, it seems like a simple, but it's very deep thing, that replace the word alien with non-citizen in law. We have always been mentioned, we have always been going throughout the provision. The word alien is used everywhere for the people who are coming from outside of the United States, from other countries, to come here and apply for the citizenship or for the immigration status within United States. They are used, they are mentioned under the word alien. So that has been proposed to change to non-citizen. Also raise the per country caps on family and employment-based legal immigration number. Now, I know this is the concern of many people from many countries. There are people from India, there are people from Mexico, there are people from China, there are people from Philippines who have applied for the employment-based petitions, employment-based green card process in common that we call, and they have been waiting for years and years and years. To follow the visa bulletin, which numbers of the visas availability every month. If you follow that every month, you will see they have been waiting for years. People have been waiting for 20 years. Since Philippines, since 1998, people from Mexico since 1998 on family category and employment-based green card process. So what this administration is proposing, which is very important, very important, raise the per country quota number, because every country has a number of visas availability, immigrant visa numbers, which they got issued every year. So they are trying countries, and mostly they are proposing to make the equal number for everyone, and to make the priority date current for all the countries, for the people from all the countries. Either they are from India, from Pakistan, they are from Jordan, they are from Kuwait, they are from Mexico. When they apply for the green card process based on the employment, or when they apply for the green card process under family process, then even they don't have to wait for years and years to get their petition go through, and then they will be able to come to the United States and start from the scratch. So that is a very important provision which they have introduced bill, and which we are looking forward so anxiously that it gets implemented, and then people who have been waiting for such a long time period, they get the opportunity to enter United States at a fast pace. Repeal the penalty that prohibits undocumented immigrants who leave the country from returning to the U.S. for between 3 and 10 years. What happens is then when people are staying in the United States, some they are able to maintain status, and sometimes unfortunately they are not able to maintain their status. They are on some kind of work visa, they are on H-1B, or they are on L-1 visa. They have the investment visas, they have invested the money here initially, and they process their, say, E-visa, E-2 visa, EB-5, and then later on, unfortunately, due to they accumulate that unlawful presence in the United States of America. And if, unfortunately, they get into the court system or into the removal system, they are removed from the United States with the bar for 3 years or 10 years or even 5 years. So this government, this administration has a provision to prohibit this and let them, if these people have already exited the United States, let them into the United bar of 3 years or 10 years. Expand transnational anti-drug task force in the Central America. Now, this is very important at our borders. What is happening there? We have very useful, very productive, very skilled workers waiting over there trying to enter United States. And then we have certain medias or certain groups or certain crime-related groups are entering United States or who are trying to enter United States. And it is very important to stop them. It's important for every administration and the government of the United States. So this administration has proposed the anti-drug force also in Central to kind of put a halt on this system and put a halt to these people from entering the United States. Increase funding for technology at the southern border. Increase funding so everything is improved at the border. The path to citizenship would give undocumented immigrants 5 years of provisional status, after which they could apply for a green card. 3 years later, they could apply for citizenship. So what they are saying that the people who are undocumented, who are applying for these provisional status, and they are able to get the provisional status, they will be giving a provisional status for 5 years, and then they will be eligible to move forward with the green card process. And once they get the green card process, 3 years, they will be able to file for the citizenship. DACA protected undocumented immigrants and can provide work history would skip the 5 years of the provisional status and have green card eligibility. So for the people who qualify under DACA and for the people who provisional period will be skipped for them, and the citizenship process will be reduced to 3 years for them, which is a very good thing because there are like approximate count for them is 11 million people who are waiting for this kind of status. So it will be very helpful for them to move faster towards the path to the citizenship and to get the legal employment. See, the very important aspect in front of the immigration system is that the people who are employed in the United States, they get the legal employment. So they have the legal status where when they are employed, they're employed under legal status and they can find the jobs easily. And even the employers can have the opportunity to hire these kind of people because if they have status, the employer has the ability to hire them. There is no restriction. And believe me, there are so many skilled people, so many professionals who have special skills can be so useful to the economy of the United States of America if they become part of the employment legally, in a legal. Now, there are certain provisions which have been implemented since January by the current government and have been lifted. Some have been lifted. So two very important points which I want to mention here is that number one, public charge rule is lifted. There was a large chaos. There was a cry out for the public charge for the people who are trying to come into the United States based on the immigrant visas, that is based on who have in common language applied for the, got sponsored for the green card process. And they were questioned because of these public charge rule that whether are eligible to enter United States, and they will not become a public charge. Number two, second thing, very important, which was becoming a very, very big issue, is the people who are applying for the green card within United States. That is, the terminology is filing for the adjustment of status. So while they are staying in the United States in any other non-immigrant status, and they are trying to gain or shift from the non-immigrant status to the immigrant status, but they have to face this public charge rule, which was, when implemented, was becoming a big hurdle for many people to apply because it was clearly damaging their eligibility adjusted into the United States. So this public charge rule as a big achievement has been lifted, so there is no more implemented. The form I-944, which has been discussed in many forums, has been lifted. It's no more a part of the adjustment of status application, and you don't have to provide with all the proofs of years and years and years, even your credit reports, your media reports, everything to provide to the immigration to see if you are eligible or one is eligible to adjust the status. Here, even after years and years, they are unable to do that. Second, very important thing which the Biden administration has done and is currently implemented is that the citizenship test question has been reverted back to 100 questions, from which was changed from 200 questions. So the previous administration has changed the 100 questions, citizenship questions requirement, to 200 questions, and that even the standard for those questions has become tougher. So that has been changed back, reverted back to 100 questions, and it has become much easier, the same as were implemented in 2008. So they are the same questions now. So whoever, it's a good news for the people who are applying or who are eligible to apply for the citizenship of the United States of America. When they put in their application, that is the N-400 application for naturalization, and they start their studying for the exam, they have only 100 questions to remember. And it's a very good news. I think so. This 200 question thing change was creating a lot of anxiety in people because of the tough questions were added in, and they were like, it was becoming harder and harder for them. Then we need to keep in mind that we have the people who are coming from the other countries, and their native language is different. So when the language barrier, though English language is one of the requirements to be a United States citizen, but the thing is that their command on that language may not be good. And when they're going through memorizing these questions and going through these questions, that causes an anxiety when you have 200 questions to go through. So it's a very good thing which has happened Biden administration, that it has gone down to 100 questions, under same criteria since 2008. So it's a very good news. And now you have to just prepare these questions and you can clearly pass your citizenship test. Some changes recommended when, as an immigration attorney, we deal through this system every day on daily basis. And my personal recommendations, which I think needs to be changed. We know that this provision, these recommendations in the bill are these provisions that are very detailed. They are like, I think so, as I've said before, more than 300 pages. So there are so many recommendations there. But there are certain recommendations while you are practicing immigration law and when you are dealing with all the problems and when you are going through the system, it is very important to pinpoint certain things. So when the people, when they go through this process, or the people, the lawmakers who are sitting there, maybe they can have, like, a close eye on that. And if you are pinpointing them, I feel this way, very important to know the important and these provisions which should be added in or which needs to be changed, because our people are suffering because of that. So one of that is the H-1B quota process needs to go back to the previous processing of the April 1st filing. For years and years and years of my practice, and for H-1B quota every year, it opens the quota for 65,000 positions for the bachelor's degree holders, 2,000 for the US master degree holders, and for them to apply for H-1B quota, which used to open on April year, 85,000. And believe me, every year USCIS has been receiving like more than almost close to 300,000 petitions from all around the United States. These are the people from all around the world, the employees who are trying to come in, and they are professionals, and they want to come in and join the employers here in the United States. So that process was going on in a certain way and was working very fine. Actually, they were proposing more number in the quota. We need all the time. We need more professionals in different. The rule was changed. They entered in a very effective manner because it's very new. And number two, there were certain changes which were implemented in the H-1B system, in the H-1B visa petition system, to make it harder. One of the very important one was the level change, the salary level change. So from level 2 or level 1, the salary level went up to level 4, which was much higher even for the employee belonging to the different fields, like in banking, in IT industry, in medical industry, in school industry, to even hire or offer this kind of salary to these very, tough for the employers who are looking for these professionals from all around the world. So luckily, and very, it's very happy announcement on my end that our current administration has taken that level down to the level 1 and 2, and they're saying, no, we do not need to go to the level 4 for these particular H-1B positions. And I hope, and that's what the need to mention this is that I hope that it goes back to the same April 1st quota system, and we can have the opportunity to get the professionals, bachelor's degree holders, and the US master's degree holders who have been students, international students in the United States, to apply for the H-1B work visa. And then when they initially get the 3 years work visa and get an extension of extra 3 years, and during that time get the opportunity to even change their status and adjust their status to the immigrant, being a green card holder. Another thing, another suggestion, recommendation on my end is asylum filing rule within 1 year of the entry needs to be changed as proposed. It's already in the proposed bill that asylum period when somebody enters the United States from different parts of the world and they have the fear of persecution and they want to apply for the status of the asylee in the United States, the basic provision says that, okay, you need to file within 1 year of the time period of your entry. Now, the Biden administration has proposed in the new bill that this should change, even if the people who have beyond 1 year, and sometimes they don't have the opportunity or they don't even know their rights to file for asylum application. So they should have given the opportunity to even beyond filing the 1 year time period, and should make that process easier for them. Employment-based green card process, priority dates should be same and current for all the countries around the world. It has been clear it has been clearly proposed in the bill, and my very high recommendation for that, being an immigration attorney for years and years, and for dealing with this employment-based issue for the people who are coming from different countries and waiting for the green card process to go through for years, maybe in some situations 12 years, 14 years, and they have to go through that tough process of maintaining their non-immigrant status, keep on filing extensions, keep on going through that process, keep on filing for the extension of the work authorizations because they have to maintain these jobs, and but still keep on waiting for this green card process to go through. So it is very important for all the countries, the quota should become equal, priority dates should become current, and even the number of the quota should increase even for the family based, for the employment based, to come and enter United States and can adjust their status as the green card holder within United States. We are going to take, so this is the brief, I have explained the bill, which is introduced in the Congress and which we are hoping will become a law as soon as possible. So we are going to implement, and it's been implemented, and it's going to give the path to the citizenship to the thousands and thousands of people. Also, there are certain, when we talk about the employment, when we talk about the people who are not by birth the citizens of the United States, people who have come from the other countries, and how they are able to secure jobs here, are able to maintain their non-immigrant status in the United States while they are leading their path to adjust their status to the green card process. So it is very important to know the importance and to know the right path to do that. Very, very important thing, which I stress a lot, is that when you are in the United States, when you are here, when you come from some other country, the most utmost thing which you need to maintain is your status as a non-immigrant. Until you become a green card holder, until you become a citizen, it is very important that if you are in the United States in a non-immigrant status, you maintain your status. If you have to file the extensions, you file the extensions in a timely way. If you have to file for the change of status, you need to file for the change of status in a timely manner, and you need to follow all the instructions and all the directions, that whatever you are following and you are following all the rules and regulations, which will not cause any problem later on for you to maintain your status. So it is very important that when you come to the United States, even if you are an international student, if you are on F1 status and you just completed your graduate program, and you have 2 years of college, you complete your studies, and now you are ready to file for the OPT, you are ready to file for the optional training program, and you file it in a timely manner. It is very important that you don't wait. You follow the rules and regulations, we very clearly mentioned on the uscis.gov website. You need to talk to your attorney. You need to know your rules to follow, so there is no mistake made in that. During these times of the, what I have noticed, and we have received lots and lots of inquiries about this, that there are students who have applied, who are in F1 status, and they applied for the OPT, and their OPTs are still pending. OPT is the work authorization for them. Usually for the general graduate program, they have a 1 year of permission to go out and find a work. And you can go in the field of your study and you can find a job with the US employer. So when they apply for the OPT, or we will mention it as employment authorization, it's more clear for many people, it's been pending for a longer period of time. So when they file, even when they file in a timely manner, it's been like months and months and months. It stays pending with the Department of Homeland Security, and it feels like that even if the permission period of 1 year is ending, and still they don't have the permission, or even if they have to, in the meanwhile, they are worried about how to maintain their status during that time with the application. So it is very important that you know that what are the rules which you need to follow, because if you are not going to follow those, or if you are not going during which you have to file certain kind of application, you file for the certain kind of permission by the Department of Homeland Security, then you may get the results in a denial, or you may get a result in the rejection, which can cause further problems for you to maintain your underlying status. So it is very important, because we are talking about the jobs, we are talking about the work opportunity available to the students, to the people, or to the degree holders in the United States, to the skilled workers. So when they have the opportunity, say if they go through their school system and they complete their education, they have that opportunity to go into the field and find a job and work in their of skills, or in their field of education, so later on, which can lead to their confirmation for the permanent job, and then these employers, they can go file for their status within United States, which can lead to the green card, or which can lead to the citizenship. So it is very important that basically when you start looking to follow these rules and regulations, oh, when my graduation period is going to be over, what is that then when I need to file for my OPT or work authorization, when I file for the work authorization, when I need to put in an inquiry with the immigrant, if my work authorization application is pending for a longer period of time. Yeah, okay, I keep on following, I go to the DHS, Department of Homeland Security website, and I keep on following that pattern, that how much time period, processing time of working on my work authorization application. So it is very important to follow that timeline, that if it's extended, you keep on following your case number. If it's extended and I need to put in an inquiry with the immigration, I need to put in an inquiry with immigration and ask them in that why there is extended period, my application is still pending, if there is some issue with your application. Further, it is very important when people apply for the work authorization, their applications are pending, it is very important they have given the right address, they have put in the right information on their application. So even if the Department of Homeland Security is trying to reach you, or if the Department of Homeland Security has some questions for you, or they are requiring some kind of information from you, they can have that information steadily available, and they can get that from you. You have the knowledge of it, or you have the access to that. It's that you miss that deadline, but they have given you to work at documents and to provide them with that document so they can complete your application process. So these are the simple things. I think so it's very important to keep in mind, to keep an eye open on these kind of things. Then with the job opportunities becoming available, during this pandemic, during the last 1 year, we have suffered. The job industry has suffered a lot. The employers have suffered. The employment has suffered. And the people who are very well employed, they are unable to retain their jobs, or the employers were unable to retain their employees, but they are looking for these employees all the time. So if you have completed your degree, or if you have completed your education program, and you're looking forward find so many, like ISGH, there are so many forums who are trying to help you out to find the job. But the main thing which you keep this in mind, that if you are an immigrant from some other country, if you are here as an international student, if you are here or any other status, if you are on the H-1B with a company, and that company, the job is no more available to you, and you are trying sponsor for you so you can maintain your status. It's not that right away, if say in many occasions we have received this question, and even the many people are going through this dilemma, if they are person A is here in the United States with the company B, retain its employees, the number of the employees, wonderful employees they have, because of the less work or whatever condition they are going through or downsizing, and that person lays off. One person who is on H-1B gets laid off. So he is looking for a job from the very first day. It's not. You are given a grace period of 60 days. During that time, the immigration understands, the Department of Homeland Security gives you certain options that, okay, if you're looking for continuously a job, you find another employer and you can do the H-1B transfer from one company to another company. So sometimes what I see, and we get all the inquiries and the questions when people get very, very anxious that if they lose a job, they won't be able to maintain their H-1B status, or if they are with a company on L-1 status, what will happen? What are the opportunities available to them, or what can they do with their immigration status if they want to stay in the United States, or if they have to leave and re-enter United States? So what I feel is that ignorance can cause many problems in that. If you do not know the ask the question. I think so. It's very important that you go to attorneys and you go to the legal help and ask them that what are the options available to me. Because if you don't know, if you are, say, if somebody loses a job and the H-1B, they are just sitting and for 30 days, 60 days, and they do not have that grace period available to find another job or look for another job, then things become very complicated, even for their to maintain status in the United States and to stay here becomes very hard. So I think so it's very important to move forward. If any brother, any sister gets into these kind of situations, they need to look for the answers. They need to look for the opportunities what are available to them, and if they can have other employees, and what are the forums they can use, and what are the job opportunities, or who are trying to help them to find the job in that way. If at this stage I have questions or any concerns from the participants, or if there are any provision, if somebody wants me to explain, I move forward with that.
Thank you so much, Ms. Chaudhry. This has been such an informative session. It's just jam-packed with information. Some people have been reaching out with some questions, so I will go ahead and just ask a few. One of them was that somebody is asking if you could give any rule changes on TN status to GC. I am on TN working since 8 years. Is it possible to change the status?
Yes, definitely. We have done many cases in our law firm, I'll talk about myself, where if you are on a TN visa or a TD visa, under NAFTA from Canada or Mexico, and you are maintaining that status, there are possibilities which leads to the green card process. So definitely cannot be discussed here, but you can have a job offer from a company and you can move forward for process. So if you have any details you need, you can definitely send us the offline question in detail about this. But the possibility is there, no problem.
Great, thank you. There was one more question. If a mother who is on a student visa passes away, what happens to the husband and the kids? How can they continue staying in the country?
Okay, unfortunately, if this situation happens and the mother is on the F1 status, mother is an international student, so the husband and the minor child, they are on the F2 status, which is the debt of the F1 status. So if unfortunately the student mother passes away, the father and the husband and the child, they lose their status F1 dependent. So they have to apply for another status, do the change of status to any other kind of status to maintain. They won't be available to be as a dependent of the F1 status.
Okay, great. Another question is, if someone gets the green card as a family member, but his wife becomes a citizen before him, does he have to wait the 5-year rule, or can he, or can he opt for the 3-year rule?
No, it will be 5 years rule for them.
Okay, just simple. There's no ifs, ands, and buts, huh?
There is no, because if the US citizen already, when the marriage happened and when she applies under that being a spouse of a US citizen and you get the green card, then you become eligible after 3 years to become a US citizen. But if you are, that is after 2 years and 9 months, you are able to put in your application for the citizenship. But if initially both of you are a green card, or the wife is a green card holder and she became a US citizen when you are, when the other person, the spouse, is a green card holder already, so the 5 years rule apply, and they will be eligible to apply for the citizenship after 4 years and 9 months.
Okay, great. Another question we had, and I had received this earlier, was someone is asking that their brother needs to come and visit them on a visit visa. How long can he stay?
Okay, usually what happens is, and this is a very good question, let me tell you that, because many people are very confused on that, okay, initially when I went to the consulate or embassy and I asked for the B2 visit visa, they issued me a visa for 5 years. So in my understanding, I am supposed to stay in United States for the 5 years time period. This is not the case. So when somebody enters States, they have issued a I-94. This is an entry and exit form. Initially, when the people who were coming to the United States on the visit visa status, they were handed over that white sheet. It's an I-94 and it gives the time period of 6 months validity stay in the United States. But what happened later on with the technology and everything, it has become online. So you can go to the i94.com website and you can have your status printed from there, showing the time period for the eligibility to stay in United States. That's the validity period. So usually the validity period, even if the visa issued to you is for 5 years, the validity period is for 6 months stay. But while you are here, expiration of the 6 months, if your brother, say in this question, if your brother wants to extend the stay, they can file for the B2 extension while staying within United States, and usually that extended period requested is also for the 6 months period.
Okay, great. There are a couple of questions in the chat. One of them is, does this part to citizenship apply to international students' F1 visas? I have already done OPT and can't get another OPT again, except I get bachelor's, which I can't afford to do. And so I think this is it. So can they do another OPT if they've already done one?
Okay, I think so. So see, when you're talking about the F1 status and when you are talking about the student visa, going through these provisions for the Citizenship Act, yes, there are provisions, which I earlier mentioned in the beginning of our session. I mentioned that there are so many things so many provisions in this bill which are not very clear, which says, oh, maybe the path of citizenship for the undocumented people who are in the United States as on January 1st. In some interpretation of that provision says that for the people, whoever is in the United States as on January 1st, 2020, able to adjust under this path to the citizenship. So it's not very clear. But with this, and you said that I cannot avail another OPT, I have to go back to register myself under another program for the international student and to keep on maintaining my non-immigrant status. And this also, earlier in the session, I mentioned that this is unfortunate that even if you don't have that opportunity available or that sponsorship offer available by any employer, any company who is willing to hire you, who is willing to offer you this green card process under employment, being a US employer, then you on going through this hard path of keep on maintaining your status, which is non-immigrant status, and you keep on doing it extended period of time until you become eligible or you found a sponsor. So the other way around, though it's a hard way, but you see, you have to maintain your status at all times until you become a green card holder. So look for a be very well educated, you must be very skilled, you must be very professional and very qualified because of your education. You are already doing your OPT, so look for a sponsor company. If there is a company who is willing to sponsor you, and you can go through that green card path process, which is still there. It's not, they're away that path. So employment-based green card path is still there. You need a sponsor for that.
Great. We are getting similar questions, so I'm going to try to condense them into one. If somebody has applied for N-400 naturalization, or if they left the country for more than 6 months while they had a green card, or if they were on a visit visa, can they, will this affect their application? Will this affect their citizenship, or can they apply for a green card while they're like on a visit visa? Maybe I condensed too much. So let's start with N-400 first. N-400 naturalization, how long can they stay out of the U.S. without affecting, how long can they stay out of the U.S. without affecting the N-400 application?
The requirement of any application, when you apply for an application, any of status within the United States, if you have a pending application with the Department of Homeland Security, not just leave the United States, because they can take it as abandoning your application, right? Mm-hmm. There are two procedures. See, one is the consulate process when the beneficiary is not present in the United States and somebody petitioned from the United States petition for them. So they are not here already and they are going to enter United States through the consulate process. They are waiting for their turn. Other situation is when somebody States and they put in their application, like we are talking about the N-400 citizenship application. So if somebody becomes eligible to file for the citizenship application, they move forward, they put in their application, now they are waiting. Now, as you know, and even before the pandemic, during the last year, the citizenship process or the processing time to do to complete the N-400 application process is much longer, much waiting as compared to the regular time period of roughly 4 to 6 months. So that got extended 1 year, then they worked on it, reduced to 10 months, then the pandemic hit. Then once the pandemic hit, they put a halt on the fingerprinting process, and the fingerprinting is the one. Once you put in any application, it moves forward with the receipt of the application, and then they send you the fingerprinting notice, so your biometrics get done. And they start the background check on you, and they start processing your application. So if there is a halt on the biometrics, yeah, the application is not moving forward, right? Which is, luckily now, we are receiving all the scheduling of the biometrics, which has been postponed or which has not canceled earlier. And now they are doing the biometrics and moving on with the processing of the application. Say with the N-400 application, if somebody put in the application, they are waiting some kind of activity going on in their country, which they cannot just ignore. They have to go. So if they have to go, no problem. Your intent is very important. It's not that you are just abandoning your application. It should not feel like that you are abandoning your. If you have application, you have to go, you leave and you re-enter after a certain small time period and re-enter the United States. Though they can check all your records, keep in mind your entry, the small, travel does not bother them a lot, and it does not accumulate towards abandoning your application. So N-400 is answered. Then the second question was about green card.
Yes. Also, when one leaves the U.S. for 2 years after permission from UCIS, does it affect continuous residence? And I guess that's why I thought this was similar.
This is the second. Yeah, this is about the re-entry permit.
And then if someone leaves the country for more than 6 months on a green card, can they still get U.S. citizenship?
Wow. Okay. Now, these are two questions. Number one question is about the re-entry permit. So one of the facility provided by the Department of Homeland Security, somebody is a green card holder, and they certain conditions in their life, or there are certain things they need to follow that allows them to not to stay in US for a prolonged period of time, and they have to go back and they have to take care of that thing. So they give you a facility to apply for the re-entry permit, which is usually for the 2 years time period. And you apply for the re-entry permit, you get the re-entry status, it's kind of a passport, and it gives you the permission that while you are still maintaining green card status, you can be out of the United States for almost 2 years, and before the expiration of 2 years, you can re-enter. But the time period, the clock starts at that time. So the clock stops for the counting towards, in the easy language, for counting towards your citizenship eligibility at the time you exit United States on the re-entry. So 2 years time period is taken off, and your clock starts ticking in again as you come back. Right? So this is for the re-entry permit. Now, as for the second question, is that the 6 months time period. If somebody, say the general rule is, and there is lots and lots of discussion on that, and I got lots of question on that, because people sometimes get the idea, and the rules have also changed on that, that, oh, to maintain your green card, you maintain your residency status, the requirement is that you need to be in the United States for 6 months or more every year until you become US citizen. So if somebody is a green card holder for 2 years, so for the previous 2 years, they can travel, no problem. They can travel for, say, 2 months there, no problem, but they have to maintain their residency, the requirement residency within United States. They need to maintain the 6 months time period within United States per year, every year for the 5 years to become eligible to apply for the citizenship. So this is very important. If in certain circumstances, it's more than 6 years, like in pandemic, people, green card holders, they were traveling because of the flight restrictions, because of the travel restrictions, they got stuck in the other countries. So much questioning has been asked on this also. So people are getting very anxious, because there are thousands and thousands of people who are stuck in their individual countries back home, and they are unable to enter United States. They tickets, they have everything, the flights are not going through, or the travel brands are there to cross the border, even from Canada. So they are becoming very anxious, because the 6 months time period, sorry, has lapsed, and they are like, okay, so it means residency status, what will happen? The plan is that there is an application which is called SB1 application, which says, okay, if you are being a green card holder or being a permanent, you have not maintained your residency in United States for 6 months or more time period, and it's beyond 1 year, you can put in this SB application with the consulate and wait. It's kind of renewing your the vows of your green card process, and then you would re-enter United States. But with this pandemic situation, there are certain things which even the government authorities, they are thinking over, that we will move forward. As we move forward, we will see how this comes up. So what I am saying is that for the people who got stuck outside of the United States currently, they should try to re-enter, and let's see how the government and the CBS officers, how I deal with this situation.
Okay, mashallah, you're getting a lot of questions from our viewers today. One more question was that if somebody is still a green card holder, can they apply for their child as a green card holder?
Okay. For the parents who are the green card holders, there is certain, yes, they can apply, the answer to that. But it depends who they can apply for. You can have kids who are married, who can have kids who are not married, or you can have kids who are under 21 years of age, kids who are over 21 years of age but still not married. So the rule says for the green card holder parents, yes, they can put being a green card holder for their unmarried children, even if they are above 21. This happens is that they can apply for their children who are unmarried. If they have married children, then they wait until become the US citizens, then they can petition children.
Okay, great. My mother has a visit visa. Can we apply for a green card while she's in the United States?
Okay, it depends what is your status. If you are a US citizen, and being a US citizen, if your mother is on a visit to the United States, yes, you can move forward and apply for the adjustment of status. Please put in the family-based petition with the immigration along with the concurrently with the adjustment of status application for your parent being the child being the parent of a US citizen. So you need to be a US citizen. Yes, while your mom is here, you can move forward and file for the adjustment of status.
Another question was about the F1 to citizenship pathway. Is the F1 status covered aside from getting a company to sponsor you?
Okay, this we have answered earlier also. I think so. This is kind of the same question. Yeah, this is kind of the same question. Either you need a company sponsor. If you do not have a company sponsor, these provisions, like I've said, are not very clear. They do talk about the international students, but not very clear. So I will be to be on the safe side. I'll be waiting for the law to figure out to come out be final, and then with the interpretation to see that whether it adds in the international students to get the path for the one who have a degree, who have a master's degree from the United States, and how they can become a national asset to the country. And there are provisions available. So we are looking forward towards the interpretation once it becomes a law.
Okay, great. So one question is, what is the difference between EB4, EB3, and EB2, and which is the fastest route to green card? If someone, and I don't know if this is a follow-up or not, but if someone fails the citizenship exam twice, what is the next option?
Wow. Okay. For that question, that answer is short, so I will answer first. If somebody fails citizenship exam twice, put in a new application. There is no restriction as to put in the new application there. Usually what happens is that when you put in your application for the citizenship and one fails for the first time, they usually give a second option. They give you the option, or they give you a second date to appear and take the retake again. If even when you go there and for the second time, unfortunately, one is unable to clear the test, the other option is to move forward, and you can put in the the brand new application in their system. There is no restriction as to put in the new application. With regards to the question for the difference between the EB2, EB3, EB4, okay, what do EB stands for? It's employment-based green card, EB, okay? Employment-based green card, but when we talk about the EB2, EB3, can be certain EB5, that's investment part. So, but through employment or investment employment, so there are certain rules and regulations which make them, which parts them, how they are implemented, how they can be used, how they become available for different people. Like if one person can qualify, the other person can qualify under EB3 category. I will start with this. See, the green card process, which we call the adjustment of status, or the path which leads to the citizenship, the first stop there is the green card process. So to apply for the green card, it starts with the sponsorship. Either it's through family sponsorship, or either the other way is through the employment. So two kinds of the sponsors there can be: family sponsor or employer sponsor. When we talk about the EB2 category, or when we talk about the EB3 category, or even EB4, which is for the religious workers and certain kinds, when you talk about these, you are talking about an employer. So there is a petitioner who is an employer and who is willing to hire you based on your qualification, or who's willing to hire you your experience and the requirement of the business, the requirement job, the requirement of that position. So if the employer is looking for somebody with a bachelor's degree plus 5 years of qualifying experience, or if an employer is looking for a job position for a beneficiary who is a master's degree holder, you qualify under EB2 category. Okay, if your qualification is, if the employer is saying that, okay, this particular job under this job title for these particular job duties, what I'm looking for, the qualification is less than bachelor's degree, or the qualification can be bachelor's without 5 years of experience, less than 5 years of experience, or skilled workers, or even unskilled workers, they also fall under EB3 category. EB3 category, it depends on the employer requirement and your qualification. That qualifies you under EB2 category, the master's degree holder, advanced degree holder, or it falls you or qualifies you under the skilled workers, it qualifies you under the unskilled workers, under the professionals with less than 5 years of experience. So it depends. That creates the EB2 or EB3 category or EB4 category. But the main thing is that you need an employer or employment company to sponsor you and to start the EB process.
Okay. One of the questions we had is, my wife is waiting for her interview at Islamabad Embassy. The NVC process is complete since January 2020. How long does she need to wait before her interview is scheduled? She has received an email from NVC that they will inform in 120 days if she will be scheduled for the interview or will have to wait longer. I am a U.S. citizen. Is there anything I can do to expedite the process, which is already long and painful?
Okay, I'm so sorry you have to go through this situation. This wait is very painful. January 2020, you said the interview was conducted. Interview was conducted? Sorry, I need to.
It seems the NVC process has been complete since January 2020.
Okay. So the interview has yet not been conducted.
It's not been scheduled, yes.
Yeah, it's not been scheduled. It's not been conducted. Sometimes, but in this situation has happened, and it was mostly part of the pandemic, part of delay or halt, which the previous administration has put on certain visa issuances. Being a U.S. citizen, and for a U.S. citizen spouse, the halt was not supposed to be there, but there was the visa halt on, or the embassy closures, all the consulate closures have played a very big role in that and has caused a lot of delay in this. Believe me, if they are they are conducting now or scheduling the interviews. So hopefully, if your spouse has already received the letter or notification or email that within 120 days or 4 months to schedule, hopefully, inshallah, that she will be scheduled within this time period. Being a U.S. citizen, unfortunately, in this situation, won't helpful, because anyways your spouse is first in the line, being a spouse of the U.S. citizen. So hopefully, inshallah, I pray that within even less than 4 months before that, she will be scheduled for the interview.
Inshallah, I hope so too. If someone has left the country for many years when they had a green card and come back, is their green card still valid? And can they directly apply for citizenship once their green card expires? I think you kind of already touch on this.
Yes, the residency requirement, very important residency requirement, which there is lack of clarity on that, and that is why I keep on mentioning in my forums and in my discussions, I keep on mentioning that keep this in mind. It's so important that you have to maintain your residency status to gain the citizenship. So if you just getting the green card doesn't matter, because the main thing is that you are maintaining your residency status to qualify to apply for the citizenship. So if one gets green card and then they leave United States and they are out of United States, then they are not maintaining their residency status, and the more extended time period involved makes it more complicated. So I believe that green card is kind of has lost its viability. And it's very important that if you have another sponsor available, or if the same they can apply for you, they need to do the fresh start for them.
Okay, thank you. One other question is, I am an H-1B applicant and my sponsor really wants to absorb me as an employee. But if I do not win the lottery, what are the other options for the sponsor to work for the organization?
See, you can either, it depends. You said you are an H-1B employee and you win the lottery, you're not on the H-1 now. Your employer must have been registered you for the H-1B process, right? So once you get into the lottery, wonderful, hopefully my prayers for you. You get into the quota, your H-1 approved, you are starting the job with the employer on October 1st. Wonderful, wonderful. Everything is clear. If unfortunately, you are not picked up in quota, you are not that this year you are not in the quota number, then you are still maintaining your status. You must be on the OPT. You can still keep on extending your employment during your period with this employer, and you need to go and move forward to maintain your F1 status or maintain any other status, and then try your luck again under quota next year. One thing. Number two thing, even on the student visa, if you have completed degree, your employer can still, now this is also very important to know, your employer can still start the green card process for you, employment based green card, though you won't, it's not the H-1B, it's a non-immigrant status. You have to maintain some other kind of non-immigrant, like F1 extension or whatever, but your employer has the opportunity or has the possibility to apply and start the green card process for you, which is labor certification, the I-140 employment-based petition that leads to the adjustment of status, which is green card.
Great. We do have a very serious question coming up. My friend dropped his green card in red paint. Now it's red.
What?
Does it make a difference?
So this is the question that is making a difference.
Yes.
I hope so. It's not a funny question on the funny side, but I think so. It's green card needs to be green in color. That's true. But the thing is that if it's red, they can apply and apply for the replacement of the green card. I think so. That is one of the possibility. First, they can try to scratch. If it's me, believe me, I will try to scratch it with a key or something. And if it's
right, because it's laminated, right? It's laminated. It's not just a paper document. Yes. So then maybe they can get a paint thinner or something.
Yeah, that's what I'm saying. You try to scratch it. But if you lose your green card, if it's misplaced, if it's damaged, if it's lost, you can file an application with the immigration and apply for the replacement or green card. They will issue you a new green card within 5 to 6 months.
Great. So how much time does it take for a parent of a U.S. citizen to get an immigrant visa?
Okay, it depends. Now this question, whether the parents are present in United States or the parents are present outside the country. So either they are coming in through the consulate process, or they are filing for the adjustment of status while staying within the United States. So it depends. If they're applying through the consulate, regular timeline is roughly 8 to 10 months. If they are applying for the adjustment of status within United States, it is a few months faster, but keep in mind the delay because of pandemic, the delay for the piling up of the application and slowing down of the process, the concept of the backlog in the immigration system. So they have thousands of files there. So that slows down the process, maybe few months, but for the parents, the consulate process a bit longer, maybe 1-2 months longer than as compared to the adjustment of status within United States, if they are present in the United States on a non-immigrant status and trying to adjust.
Okay, great. And a question from a viewer is that we have been here since 2016 on B1, B2 visa. Are we eligible for anything? My kids started school from 5th grade and another started from 9th grade.
Okay, if you enter United States on a B1, B2 status in 2016, either you file for the extensions, like first extension, second extension. It's a longer period of time to be on a B1, B2 status. So this is the same thing which I answered before. 94 issue, the issue of the validity of the time period of stay in United States. This is the misconception I talk about, that they must have, in my understanding, they must have the issuance of the visa. That is, the visa page shows the 5 years of validity for the B1, B2 status. But when you enter United States, the validity of the stay is not more than 6 months. Even when you stay here before the expiration of the 6 months, either you file for the extension of the stay or you move forward and file for the change of status to some other status. So I think so. I'm afraid that if you have not applied for any kind of extension or of any kind of change of status, you are by now out of status. And it's been many years, almost 6 years. So if you are out of status, the last 6 years, I think so the safe side is to wait for this bill to become the law, because once it becomes the law, inshallah, hopefully it will have some provision for under amnesty or under the provisions which are introduced in that you will be able to adjust your status. And certain provisions also apply. Keep in mind. Whenever amnesty has come, this is not the first time. America has amnesty many times, 3, 4, 5 times during the last many years. And whenever there is some kind of amnesty introduced in the system for the people, there are certain restrictions that are clearly and very clearly followed. Good moral character, no criminal history, you have been a good citizen, you have followed all the rules and regulations of the country, you have tried to make your life better, you have filed taxes. There are certain restrictions or certain requirements which needs to be fulfilled. So on this note, I will like to add in one thing, that the people who are looking forward, there are thousands and thousands of our brothers and sisters who are unable, unfortunately, to maintain their status, and they are looking forward to this amnesty for years and years to adjust their status. If they are there, kindly start looking into these things. Try to add in or take a box, put your stuff in there related to your stay in United States, related to your history, related to your taxes, related to your proof of being a good citizen. All of this is very, believe me, once this process out, when this law is come out, these things will go a long way in strengthening your case for you.
Great, thank you so much. Do we know currently how long it takes to get citizenship for a green card holder?
Okay, if you put in the application, roughly for right now, it's the processing time which I'm following, even during the pandemic thing, and now it's taking about 8 months. We are getting the interview dates and getting the oath ceremonies for the people I think so within less than 10 months time period right now. So move forward. If you are eligible to apply for the citizenship, move forward, and hopefully even the time period will become shorter, the processing time period. So roughly it will go back.
Okay, great. Sister Karima has a question. My husband and I received an email from the embassy for a letter from our sponsor. We had the letter notarized and sent to the embassy in Ghana. We haven't heard anything, and that was in December 2020. Do you have any idea what a reason for a holdup could be from them responding to us? They did receive the email. It was received.
Oh, so you got the follow-up email that the document had been received, right?
It sounds like that,
okay.
Yes.
Okay. See, this seems to be because of the pandemic hold. This seems to be because of the halt of the visas. This seems to be all that situation involved. So hopefully, if they have acknowledged that they have received your documentation, they have completed, they will be scheduling for, for the within, because this process has started now. So hopefully when they out of that pile, so just keep in mind there's piles of documents there, files there they are working on, which were on hold. So hopefully you will be hearing from them soon.
We have another EB2 question. How long does the EB2 process take place? Also, if one has a child who is under 21 and unmarried, and the process is under EB2, and if it takes more time than your child passes 21, then what will the status of the child who passed 21 be, even though they're still married? They were still unmarried by the time the green card process was approved.
Okay. So what happens in this situation? An EB2 process is going on. Factors involved: number one, which country of the origin, which country it involves, how much time, processing time period, what is the priority dates involved in that. So all of these factors are considered. Number two, is a child involved, and the adjustment of application, this child along with, after the approval or filing, or along with the filing of the I-140 application, when you file for the I-485, which is the green card application, you add in your family members there. The child is under the 21 year age at that time, the child slips in. And then even during of the 485 application for the child crosses the age of 21, he or she still qualifies. So she is in the line, problem, or he's in the line, no problem, they can still be added in. If during that process, say if the 4 is still not filed and the child crossed the age of 21 years of age, then once you get the green card and you become a green card holder, you can your child for the green card process. And also to add in one thing, this is in the provision. So this is in the comprehensive immigration reform bill, to make everybody, to even for the kids who age out, to not to kind of take them out of the applications. So once this provision or this bill becomes the law, it will have that provision. Inshallah, we are hoping that the aged out kids will still be the part of the application when the adjustment of status happens. So hopefully we are looking forward to that.
I hope so too, inshallah. The other question is, I am currently pursuing my master's in education and wanted to apply for EB1. Is it still possible for me to apply while I'm doing my doctorate? The possibility of EB1. Okay,
EB1, the criteria is very tough. EB1 is extraordinary abilities, researchers. There's so many strong criteria. And I know, mashallah, PhD program, and you must be so much qualified. Now it depends. What kind of qualification you are basing your EB1 on. Your PhD program, besides your PhD program, you have another PhD program, you have a master's degree, you have extraordinary ability established on other qualifications. You are a researcher, you are a national interest waiver qualified. So there can be so many possibilities which qualify you under EB1, but I highly suggest, because of the tough criteria which Department of Homeland Security follows for the EB1 category, it's important to talk to an attorney, immigration attorney, while you are looking for your qualification and possibility to slip in under the EB1 thing.
Great. Another question is if there are decisions that include special asylum in customs and traditions issued by President Biden and approved by the House of Representatives. If we applied for asylum in December 2018, I guess any special decisions that were made? The question was a little unclear, I'm sorry.
Yes, so this, the question is that they have already applied under 2018. So apparently their asylum application is in the system, right? So if it's pending, it's not decided, but we are hoping, and there are so many about the asylum status. There are so many provisions, so many leniency which are being offered in this bill, is that passes, it will be kind of a clear path for the asylees to the citizenship and to gain the work authorization and to have a clear and a very less tangled way to the citizenship. So I'm hoping, and until you are not, the asylum is not decided, it will be implemented on your application as well. So we are hoping, and we are keeping a very close eye to this bill. But there are so many provisions in the favor of the asylees, just like DACA, just like TPS, just like VAWA. So we are looking forward to that.
Okay, great. Anything new in the WAVA process, WAVA?
VAWA.
WAVA.
So VAWA, VAWA is the battered spouse petition. So it's the petition for the battered spouses. And apparently the VAWA provisions, there was change initially in the VAWA provisions years ago, I think so close to 2008. Provision in this bill, they are talking, showing more leniency to the VAWA applicants and to the petitioners. So we are hoping, see, when you apply for VAWA, the criteria is very lenient. We have done countless VAWA cases, countless asylum cases, and we know that when it comes to the victims, when it comes to the victim of violence, when it comes to the victim battered, when it comes to the fear of persecution, fear of life-threatening situations, all that, the immigration eye becomes very lenient, and they give them very, very leniencies and very open, open arms policy. So I think so for VAWA, whatever as such provisions, they are implemented, they are there, but they are about giving status VAWA applicants also more rapidly as compared to whatever they go through if they are the victim of a battered spouse of a green card holder, or as compared to the battered citizen. So that provision is also there. Also, we are in the waiting list to see how it's going to get implemented.
Okay, great. So what do we do if we didn't apply for tax when we moved to the United States? Can we still apply now?
And okay. No, so it's not clear for how many years you have been in United States. So if you just moved last year, or you have moved 5 years ago and never filed taxes, I'm not a tax expert, but with the tax experts, you can file taxes. So that possibility is available. If you are even making income and you are taxes, you can go and file the taxes with the IRS. It's always better to file taxes, even late filing. So I think so you should talk to your tax expert and ask accountant if you are eligible to file and do the back taxes. So
she is saying that, I apologize, she is saying that they moved here 5 years ago.
Yes. They came here 5 years ago? Sorry, I can't. Okay, yeah. Still, my understanding it's better to ask from not to ask. So I think so. I have seen back taxes being filed later in the years. Even people file the revised taxes. So I think so. The best route to take here is to talk to the tax expert and accountant and file your taxes.
Great. All right. Thank you. Are there changes in immigration laws with regards to siblings?
No, for right now, no. You can apply for the siblings. Yes, a U.S. citizen can apply. Once you become a U.S. citizen, you are able to apply for your siblings, and it takes a longer time period. The priority date takes like 10, 11 years roughly, which is a very long time period. For right now, as I'm saying, in 300 pages, we don't know what will become a law and what will, a rule and will not become. They have always said earlier, there were talks about, okay, why even there is a sibling category? We can just take out that category because it takes a time period. They are talking about reducing that time period on the family-based petition, which which will include the sibling category also. So we are hoping that there will be good news for the sibling category as well.
Okay. I applied for a green card for my wife and stepdaughter from Pakistan 3 months ago. How long could that take?
So you applied for the green card for your spouse and she stepped out, or you?
I'm sorry, her wife and stepdaughter.
And okay. Sorry. Okay. See, the process a little bit longer as compared to the wife, the spouse. So maybe if the processing time right now is, say, it's taking 7-8 months for the spouse of the US citizen to process, for the stepdaughter, and it also depends, minor, major, it also depends on that. So it depends on the age factor. So it's roughly 2-3 months more. And sometimes depending on how they are proceeding with the applications, if the petitions are proceeding together and the child is minor, they do process them at the same time and let both the child and the wife hear in 7-8 months.
Okay, great. Thank you. Another question is, should I apply for citizenship if I already completed 5 years as a green card holder, even though I lost my job? Or should I wait until I land a new one?
It has nothing to your citizenship, applying for the citizenship, or your qualification to apply for a citizenship does not depend on your job, having a job or not having a job. So it depends on the time period. If you accumulated that time period, 9 months into United States, or half of the time you were present during that time in United States, which is 30 months, or which comes to 2.5 years or more, you are eligible to apply for citizenship. So please move forward. You are eligible to apply.
Great. My wife has a green card, but I don't remember how long it's been, or how I can't tell when. Is it eligible to apply for the U.S. citizenship? Is there a website or an entity I can call to know when exactly I can apply for her citizenship?
Okay, so see how she got the green card. If you are a U.S. citizen and she got the green card on the marriage to a U.S. citizen, then she's eligible to apply for the citizenship after 2 years and 9 months. And she must be like past that time. So 3 years time period, 2 years and 9 months, you are eligible or qualified to put in your application. If at the time when she gets the green card through some other source, through the being U.S. citizen, it's 5 years criteria. So after 4 years and 9 months, she is eligible to put in her application for the citizenship.
Okay. I am currently on H4. Can I work?
See, now this question depends. If you are on the H4 status, it depends on, there is certain criteria where you become eligible to apply for the work authorization. So if say the criteria, I can read that to you. So is the principal beneficiary of an approved form I-140 immigrant petition alien worker, okay? Number 2, principal beneficiary is the I-140 is approved, of the husband's I-140 is approved, or she herself, she has filed I-140 and she's a beneficiary or has been approved on that. Number 2, has been granted H-1B status under section 106AB of the American Competitive, or either she has applied for the H-1B and herself has qualified under H-1B. So my answer is that the criteria is the approved I-140. If the I-140 is approved, yes, you are eligible to being on the H-4 status.
Okay, we seem to have a longer question here.
Okay.
What is the next step for R1, R2 religious denied in extensions, teachers or workers for a legal stay in USA with work authority and travel documents? And then there's like a couple of bullet points there. Who filed asylum already 1 or 2 years before, can they file for provisional visa? Or who didn't file and are undocumented for a few months, are they eligible to file provisional visa? Do you want to answer it one by one, or do you want me to tell you all the categories at one time?
Okay, actually, I have this question written
Yes.
in front of me because you shared it with me earlier. So what is the next step for the R1, R2 religious denied religious visa? Denied in extensions, teachers or workers for the legal stay in USA will work authorization and travel documents. So apparently it's two questions in one. First question is if the R1, R2 religious denied, status denied, in extension, how they can stay here. It's my understanding of the question. So if the R1, R1 status. So if the R1 extension denies, you are out of status, unluckily, and you have to either apply for another change of status or exit United States. Second question is, and if a person who filed asylum 1 or 2 years before, they can file for provisional visa. Now, this is, in my understanding, provisional waiver, or who's didn't file yet and undocumented for the few months, are they eligible to file provisional visa? So if you by provisional visa you mean provisional waiver application, that is usually filed based on the eligibility and based on the qualification for the people who are not maintaining this status or who have not maintained this status in United States and have a qualifying relation available. Based on that, they are eligible to file for the provision. If they have in the meanwhile already filed the asylum status, or if any asylum application, any other kind of application is pending for them, yes, still they can move forward and file for the provisional waiver. If you are asking for that, it's not that clear, the question. Also, the second part I think so related is who are dependent and undocumented and 21, reaching 21 age soon, should they file separately or with their parents? So if a child, and this I have already answered before also, if they are under 21, they will be added in along with their parents, but or along with the other family members. But if as they reach the age of 21, then they are no more dependents of their parents' visa status and have to maintain or apply separately from their.
Okay, thank you. A new question is, my friend is asking if she can still file an extension for her mom that entered the United States in 2018 through visitation. She did not file for an extension for her before. She is a permanent resident and going for a citizenship interview in May 2021. So the friend is going, it seems like the friend is a permanent resident and going to go for her citizenship interview in May of this year. And she wants to file an extension for her mother who came in 2018 through visitation, and she has not applied for an extension before.
Okay, so if she has not applied for the extension and the mother is there in 2018, so apparently the mother is not in status. And if she is not, even if your friend become a US citizen and the mother has accumulated time here, then it's a tougher situation. Maybe she has to file, she can apply for the adjustment, but she has to apply for the waiver, or maybe the immigration will require for her to file for the waiver application also along with it. So it's a bit complicated to answer, to have a direct answer on that, but there may be because mom is not maintaining status in United States. So if it's not filed in a timely manner, it's not that she is here since 2018 and no extension has been filed and now I'm going to move forward and file an extension, it will be useless. But if she's doing that because she will be becoming the US citizen and she's thinking, okay, once I become the US citizen, I will move forward and apply for my mom's adjustment. But at that stage, if your mom is not maintaining the status, it won't be possible for her to file for the adjustment without putting in the waiver application in between. So I think so it's important in this situation to consult an immigration attorney on that.
Okay, great, thank you. I am going to switch back to our emailed questions. Green card, I'm not sure how to translate this one. A green card for family, children above 21 and married. How do I
I'm
do
trying
what?
to make it a question.
All
Yeah, I
right.
think so. It's yeah, I think so. It's the same question. They are saying that if you are a green card holder, I think so. That's a part of the question we answered earlier also. That
Great.
if you parents become a green card holder, whether they sponsor their child who is under 21, yes, they can sponsor the child who's under 21. But once they become, or if they are over 21, then they are not added in along with them, and you have to, sorry, if they are unmarried you can petition that, but if they become married even under 21, then you cannot petition them. You have to wait until you become a US citizen.
Okay. This question is, my husband is in removal proceedings. Currently, he is under ICC supervision program,
Okay.
and he reports almost every year since for the past 6 or 7 years. My kids and I are U.S. citizens. I guess the question is, what can they do to avoid this?
Okay, yes, I think so. My understanding is also that the husband is in the removal proceedings, and once they are in removal proceedings, they sometimes they go under that program where they are supervised stay here, and they go and report every year to the ICE that they are still here, and to just as a checking program. The spouse is a US citizen. Unfortunately, it depends whether the removal proceeding is still going on, and there are certain provisions available where they can go to in front of the judge in the court system, and they request for certain reliefs being a spouse of a US citizen, certain relief being a spouse of the green card holder. So I think so they an attorney because to the husband in the removal proceeding, and the attorney should know that if they have this relief available, if the children who qualifying children, which is 21 plus age, and they can petition their father, and the spouse who is a US citizen, and she can petition the husband, there is relief available in that form under certain applications and petitions in the system. So it's very important, talk to the immigration attorney and if available in front of the judge.
Great. I am trying to employ my 2 nephews from overseas in my new business. How do I go about that?
Okay, can you repeat the question? Sorry, there was a little breakup in between.
I apologize. I am trying to employ my 2 nephews from overseas in my new business. How do I go about that?
Okay, this is the emailed question also. I saw that. And when I was reading this question, I was like, okay, what is the basic, the question in this? And I think so what they are trying to ask is that it's a company holder, it's a person who has a business here. And he says that, okay, I have now it depends whether he has already employed these nephews in the, or these nephews are outside of the United States, and he's trying to employ them under his company, right? So it depends whether they are trying to do that process, employment-based green card process for the nephews, or they are trying to just file the H-1B visa. If they are just trying to file the H-1B visa under the company, it's a US company which petitions the H-1. Yes, move forward. Under the, if you are applying for the employment-based green card process for the nephews, it depends whether they are the nephew relation comes under the qualifying relationship where you can directly as a relative file a petition for them for this under sibling petition for the parents, or if that criteria still qualifies there. If then there is issue, because then they say, okay, if you are filing an I-140 petition for your nephews, you forward and file an I-130 based on the family-based petition instead of the I-140 petition, and you are not taking away 2 positions. But if you are applying for the H-1B, yes, you can move forward. Your company can file the petition, H-1B petition for your nephews, no problem.
Thank you, Ms. Chaudhry. How are the new policies, how the new policies could be beneficial for students on CPT or OPT?
Okay, CPT, OPT, that means the optional or the curriculum training programs, what our students do, the international students who are here. For right now, I've gone through roughly when I went through the bill, it's a very detailed one again and again, I mentioned that. But when I provisions, I looked for the provisions for the OPT or the CPT, any kind of particular thing which is mentioned. Though they have mentioned the speedy process for the international students, the speedy process for the degree holders who are getting the degrees from the US, but there is no particular, very clearly on OPT, CPT. So we are still waiting. Once this bill becomes the law, we are able to interpret it, legally interpret it, then we will have a clear picture.
Okay, great. I'm not sure if we addressed this because I know I've heard EB2 several times, but what are the changes to the EB2 category?
Okay. For right now, the only change what they are suggesting to make the priority date current for all the countries. They're also suggesting to increase the visa number from 130K to 170K, I believe, and to make it for every country, the same quota for every country, and to make the priority dates current for everyone. This is the most recent, the provisions which they are asking to implement in this bill. Other than that, EB2 category stays the same, the requirement, the qualification stays the same for as of.
Okay, great. Well, that is all the questions that I think we've gone over them. Thank you so much to Ms. Misbah Chaudhry for taking the time out of your weekend. We actually do have one more question, if you don't mind. I am in Pakistan. According to State Department Visa Bulletin, current date is 2016 November cases. It will take another 3-4 years when my parents may get the interview. I am planning to come on a student visa to USA. I will pass the age of 21 when my parents will get immigrant visa to come. What can I do?
So you are saying that your parents, so some qualifying relation has applied for your parents as well as your name is added in there. This is my understanding.
Right.
And then you are saying that during that time, because the priority date showing on that as 2016 currently,
yes,
parents have applied for you. So it depends, the clarity. And during that time, you want to come into the United States on a non-immigrant status or a student. Yes, you can. There is no restriction whatsoever. And this is also what taboo, which people talk about a lot, or a kind of myth, I think so, that, oh, if your, if your petition has been filed or pending in the system, you do not qualify or you cannot apply for a non-immigrant visa. Believe me, that's not true. There is no restriction whatsoever in the immigration laws or rules and regulations to restrict you or anyone to apply for the non-immigrant visa while you are a candidate of an immigrant visa. So unless, depending on this bill, if it becomes the law and hopefully inshallah your dates become priority dates, become current and speeds up the process, if there is delay there, you in the meantime, if you want to move forward and apply your luck and apply for the non-immigrant visa, go ahead, please do give it a try. No problem.
And then the follow-up is, will my parents be able to adjust my status when they move here?
When they move to US?
They come in a student visa and then their parents do come, can the parents change the child's status who is over 21 at that point?
Yes. So like I mentioned before, that once your parents are here on a green card status and you are unmarried, they can, being a green card holder, they can file a petition for you.
Okay, great. Sorry, there is one more question popping up. Just to our viewers, if you guys can put in your questions now because we will be wrapping up shortly. So any changes or updates if I applied for my brother who is in his 30s and his family? I applied 4 years ago and they told me it will take 13 years or so. Is there any luck that this could be shorter or faster under Biden's new rules?
Yeah, it is like this also we have mentioned earlier, because people are so concerned. 10 years, 11 years, 13 years, a long time period. Seems like a lifeline, long time period. Believe me, this. I have dealt with the sibling categories where they apply for their visas and say, we applied, we thought it's never going to end, but now we are processing. They are constantly going through the consulate process. they are getting here. So time passes by. But yes, in these provision, we are thinking that under the family petitions, where they are asking for the priority dates to become current, we are asking for to speed up the green card process for the family-based petitions, including the sibling category. So we are really looking forward to have a shorter time process these kind of applications.
Great. And that is the end of our question and answer session. Once again, thank you so much, Ms. Chaudhry, for taking the time out of your weekend and helping our community by answering these really important questions. Immigration is a hot topic, always has been, and most likely always will be. So we really appreciate your time. Thank you also to our viewers and our participants who took the time out also to join us. We hope you have a wonderful rest of the evening.
Thank you so much for having me, and thank you and good everyone. Thank you so much. Assalamu alaikum.
Wa alaikum assalam.